having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
People against Keith Campbell.
Ready, people.
Ms. Fahey, good afternoon.
Good afternoon. I would submit that a delayed sentencing issue can't be waived because it goes to the very power of the court to impose sentence. But I actually think that the other reason I would submit to you is more fundamental, which is that since a waiver, do I have to talk louder?
We apologize.
Yes, we have our apologies. This was supposed to stop, and it will.
I'll try to. And that's that since a waiver must be knowing and intelligent, I would submit that it can't fairly encompass issues that relate to events that haven't arisen yet, that the defendant hasn't been warned about, and that he can't reasonably anticipate arising. And I think all of that is true here. I would suggest that when you're talking about past events, obviously the defendant is on notice that when he's waiving his right to appeal, he's waiving issues that are going to relate to those past events.
Is there any difference if, because you spoke about events that he couldn't anticipate, how about his use of 4 different names, his being arrested on bench warrants, his failure to appear repeatedly? That seems kind of like stuff he's in control with. Shouldn't the waiver, doesn't the waiver at least have some kind of good faith or out of your control kind of scope to it? Or your interpretation allows the defendant just to take off and then later raise a constitutional, speedy due process kind of claim, doesn't it?
Well, Your Honor, that suggests importing the merits of the delay issue into the waiver issue, and I would suggest that the two of them are really distinct, because the waiver turns on...
Let's talk about this for a second. The waiver is, the individual waives any claims that he or she may have. Now, wouldn't that waiver have implicitly within it an agreement that that person's not going to flee and any ramifications thereof, or not misrepresent himself with 4 separate aliases? Doesn't it strain things a bit for us to say that we condone this kind of conduct by not having the waiver be effective against it?
Well, Your Honor, that's really, again, that's really the merits of the issue. If, in fact, the delay is his fault, then an appeals court considering it, if it gets past the waiver, then considers the merits, and he may lose on the merits if it's determined that it's his fault. I mean, here, in fact, he didn't flee the jurisdiction. He gave the same name that he had used in this case 4 months later in court in another Queens drug case. And then he was incarcerated in New York State under his own name after that. So these factual issues are very much contested.
He used 9 different dates of birth and had 4 different state ID numbers.
Your Honor, that's true. That's true. But I think the issue here is a much broader issue than involving just this defendant. The appellate division decision is simply that a general waiver of the right to appeal waives a delayed sentencing issue, period. That means it really doesn't matter if the defendant is at fault or not at fault at all. It would apply to defendants who spend years in prison under their own names, never use an alias, and have their sentencing delayed. It would apply to people who have the prison write the court and say, he's here, come get him, and they don't bother for years.
If we agree with you, what are the consequences?
Your Honor, the consequences are that when there is a delayed sentencing issue, the appellate division will consider it on the merits.
So does this have to be reversed and remitted, or can we take into account the facts such as those recited by my colleagues?
Well, Your Honor, with all due respect, I think that the factual decision is not within your jurisdiction. This is a very heavily factual question. The appellate division has never considered the facts.
This is a question of whether the delay is reasonable. You're saying that in each instance, a waiver of the right to appeal does not preclude an exploration of the reasonableness of the delay.
Exactly.
In a nutshell? Okay,
Exactly.
Let me ask you this question. If we were to go with you in this, would this discourage the kinds of rehabilitative plea arrangements that we have from time to time seen come up here? You must be more familiar.
Yes,
You
sir.
must be more familiar than I. You know, we have a drug addict with a low-level possession charge, and they want to see whether the person goes through rehab. Now, if we decide the case the way you're suggesting, wouldn't that discourage prosecutors and courts from entering into those very, we think, quite socially productive arrangements with deferred sentencing?
Right. Yeah, I understand your concern. I don't really think that it would interfere with that at all, because that's a very different situation. In that situation, at the time of the plea and any waiver, the parameters of what's going to happen are spelled out. You're going to go into a drug program. We're going to delay the sentencing. You accept that. If you succeed, this is what will happen. If you don't, that's what will happen. So that delay is something that the defendant agrees to. So in that situation...
But there has to be a hearing, though. According to you, your position here, the waiver of the right to appeal in that situation, there'd have to be a reversal and send it back to the trial court to have a hearing as to whether the delay was reasonable.
No, Your Honor, because in that situation, the defendant has agreed to the delay up front. At the time of the waiver, he agreed to the delay. I mean, maybe in that situation, if they then lost him in the system somehow for years, maybe there would be an issue. But if, in fact, it's the standard couple of years in a program, I don't think that issue would arise, because he specifically knew about that when he waived it.
So you say that makes a difference because the fact was, it's like Hidalgo, it's a fact that's known in advance,
Exactly.
and the defendant's kind of accepted the jeopardy in a different
Yes,
sense
right,
than what
right.
you and I would think of it as,
Right.
that responsibility. I wanted to ask you, Judge Smith asked you what would happen here. The trial court didn't say that the waiver or that it was precluded from deciding reasonableness. There are findings. If there was a remittal, it'd be to the AD to just take up whether the trial court's findings were correct and its conclusions were correct.
Correct.
Okay.
Yes, Your Honor. Precisely.
What's your best precedent, Ms. Fahey, for the recognition of this right?
Well, there's no case I know of that's squarely on point.
Well, Drake says it's jurisdictional.
Excuse me?
Drake says it's jurisdictional.
Says it's jurisdictional, yes. So I would suggest that Callahan is helpful here because it talks in terms of the power of the court, and the fact that a waiver doesn't encompass issues that go to the power of the court. Here, of course, it's the power of the court to impose any sentence at all. So I would think that if the court, if a waiver can't waive an issue that goes to the court's power to impose a particular sentence, then how can it go to the court's power to impose sentence at all? And I would suggest also that there are a host of cases, and this area obviously is still developing, but Hidalgo, for example, and the various enhanced sentencing cases that the appellate divisions have been dealing with, seem to draw the line at was the defendant given fair warning at the time of the plea and waiver of what might happen. So if he's told the sentencing range, he may hope for better than he got, but he waived with fair warning of what could happen.
But
He has to be warned?
by saying if the court had said, look, if you abscond or if you misrepresent your identity or if you misrepresent anything about yourself in an effort to hide yourself from me, you're waiving any claims that arise from that, including any rights under the statute to be sentenced in a reasonable time. That would have been okay, wouldn't it?
I think that would have been okay if that had been specifically spelled out to him, and he had been specifically warned.
He has
I
to be
think-
warned he has to be warned not to use 9 dates of birth and 4 different state IDs. You have to warn someone about that? Isn't there a modicum of faithfulness that one can expect implicit in one's relationship with the court?
Well, Your Honor, not all defendants are all there, to put it simply. And this guy used a lot of aliases. He had a lot of difficulties. He is not. He's neither a sterling citizen nor is he someone who makes a lot of sense a lot of the time. But I think once again, the issue goes beyond his case. I have a case now in which a defendant was in the New York State Department of Corrections under his own name, the same NYSED number, for 6 years and wasn't produced. That case is now in the appellate division. There was a waiver of the right to appeal when he pled guilty. I know that under the appellate division cases, the people are going to argue, and unless this court says differently, they will be successful in saying that since he waived his right to appeal when he pled guilty, it didn't matter, that issue is foreclosed to him because he was, because of the waiver. And the appellate division decision in this case has very wide impact. What I would suggest is, in a situation like this, the appellate division has yet to reach the merits of this issue. All we're asking this court to do is to say, reaching that issue isn't precluded by this waiver, send it back to them, and if in fact he is as bad as he seems on the basis of some of these facts, then he may lose on the merits, but there may be a heck of a lot of other defendants whose merits issues are much better, who will otherwise be precluded from raising them if this appellate division decision stands as it is.
Thank you, Ms.
Thank you.
Mooney. Ms. Aldea?
Good afternoon, Your Honors. May it please the Court. Defendant basically posits that a waiver of a right to appeal should never be enforceable, ever, as to a delay sentencing claim in any case, because there exists this hypothetical defendant that she keeps referring to in a hypothetical case where the defendant is utterly blameless for the delay and where the defendant has taken multiple steps to try to be sentenced, has written letters to the court.
Defendant could exist in another case.
Well, Your Honor, it could exist. However, I would posit two answers to that concern. The first is that if this utterly blameless defendant does exist, redress would be available to him even if this court does not expand the general exception, the narrow exception to the general applicability of the waiver rule.
Tell us what redress would be available.
The redress that would be available there is actually the second facet of the defendant's argument here, and that is that the waiver in such a case, in the case of a blameless defendant, would likely not be predictable, would not knowingly encompass a delayed sentencing claim in that type of case, because there, the defendant, by being utterly blameless and by asking the court repeatedly to be sentenced, would have no means of predicting that a delay in his sentence could arise. That is one possible
So that defendant would have a good claim, in your view?
Well, Your Honor, it would depend on specifically how the waiver is worded, but that is a possible avenue of redress for such a defendant.
So that would be a good claim?
Your Honor, yes. Well, that is the reason that the exception with respect to the first portion of defendant's claim here should not be expanded, because it's unnecessary to expand the exception in order to accommodate this hypothetical defendant.
Well, what about if there are some conflicts of facts as to who's the fault, who's not at fault, whether or not it was a goof up by the computer rather than evasion by the person who's in prison and can't appear for sentencing, and nobody knows what the story is at all. Now, you're saying we're in that situation, then what happens is this person, the waiver, according to you, the waiver would be binding, and the appellate division would be deprived of factual review of the trial court's determination. Is that basically the way this would play out?
No, Your Honor. And
tell me how it would play out.
The reason for that is that in determining under the second facet of this, assuming this court does not expand the exception, and the claim, which can always be raised, and in fact is also being raised here, is that in a delayed sentencing case, you can never have a knowing, intelligent, voluntary waiver because you can't predict this future claim. In that type of case, with the example that Your Honor has raised, what would happen is, in fact, the appellate division, when the defendant asserts the claim that his waiver was not knowing and intelligent as to the delayed sentencing claim, the appellate division would be forced to look at the facts of the case. And in fact, the defendant misstates the law when she says that this court has no authority to look at the underlying facts. In People v. Seaberg, this court very explicitly explained that the way that the voluntariness of a plea and a waiver is determined is by reference to the unique factual circumstances of every case. And that's why it's not incorrect here, under this facet of the argument, for this court to look, as Justice Wesley was saying, to the underlying facts here. Defendant knew at the time he was standing before the court that he had used several different names. At the time, I believe he had only used 3. Ultimately, he wound up using 4. He gave a total of 9 different dates of birth. He gave a total of 5 different places he was born. He knew when he was standing before that court that if he ever came back 1 month later, the time that sentencing was supposed to occur, he knew at that time that the court would discover that he did in fact have a prior felony conviction. And the court would discover then that it could not sentence him to the 6 months it had promised because the defendant had lied.
I just want to make sure I understand that the rule of law that you're advocating here. Is this a narrow rule of law limited to this case where you have somebody who their findings that the delay in sentencing were due to his own evasive conduct, which of course he could predict and control? Is that the rule of law that you're saying here? The waiver will control when the delay in sentencing is attributable to knowing, intentional, evasive conduct by the defendant. Is that the rule you're advocating, or is it something broader than that?
Well, Your Honor, essentially the rule that we're advocating would depend on which facet of the claim. With respect to the claim that the general exception needs to be expanded, defendant advocates in this case that in fact no waiver of this type of claim, no waiver could ever cover a delayed sentencing claim. There we would take the view that the exception absolutely should not be expanded to cover this type of situation because it's not akin to the situations where this court has expanded the exception. However, with respect to determining whether the waiver was knowing, intelligent, and voluntary encompassing this prospective claim, it would be necessary to engage in a fact-by-fact analysis. And there, all this court need do is hold a narrow rule, one applicable to this case, that in a case...
Go ahead, finish. I didn't mean to interrupt.
That in a case where a defendant knows at the time that he is entering into the waiver that he has used various aliases, and where he knows at the time that he is entering into the waiver that, and has reason not to return for the sentencing date and causes the delay, that in such a case the waiver must be enforceable.
How would, this would be a little different. This would be something a little new, wouldn't it?
No, Your Honor.
You don't think so? The appellate division doesn't seem, I mean, all we know from the appellate division is they said the waiver covers it. But we don't know that the appellate division decided that the waiver covers it because the waiver itself was knowing and intelligent and voluntary, and that kind of knowing side of it was such that he knew or should have known his conduct from this obviously sprang from this. Wouldn't that, I mean, if the rule you just articulated is what the rule ought to be and what the rule was if we declared it, wouldn't we send it back to the appellate division and ask them to decide whether those findings of fact were supported or whether they decided to insert different findings of fact?
No, Your Honor. The reason for that is that the appellate division in its decision, in fact, I think did say that the waiver was knowing, voluntary, and intelligent. And in doing that and in citing to precedent that holds, as this court did in Seaburg, that it's necessary to look at all of the circumstances of the case, including the defendant's experience, his age, the unique circumstances before the court, the appellate division necessarily made that finding. Now, while the court is correct that the appellate division did not go through enumerate all the factors before it, it nonetheless should be deemed to have made those determinations in reaching its decision.
We've said with respect to waivers of rights to appeal that they won't be enforced if the issue is one that has a public policy and public importance apart from the rights of this individual defendant. And we have also said in cases that prompt sentencing is a societal value as well. Now, if you put those two together, don't you end up with the general rule as far as delayed sentencing is concerned that Ms. Fahey is advocating? And how do you get around that?
No, Your Honor, you do not end up with that general rule. And the way around it is to look simply at the ways, the different types of claims that the exception has been deemed to cover. One example of those are constitutional speedy trial claims, and another example of that would be a claim that the sentence is actually illegal or unauthorized. The final example would be that the defendant is actually not competent to stand trial. Now, all of those have been held to implicate larger societal concerns because if you look at the individual rights involved for constitutional speedy trial, it's been held to be inherently coercive to have a defendant plead when so much time has elapsed that at the time he's entering into the plea, he no longer has the ability to defend himself. So there, society has an overarching interest in ensuring that an innocent person is not convicted.
So we misspoke when we said that there was a societal concern that
No, Your Honor.
people get sentenced promptly and that they go through the process of punishment, rehabilitation promptly and all that stuff.
No, Your Honor. There's always a societal concern with any piece of legislation that's enacted. And in fact, the perfect analogy is double jeopardy claims. This court has repeatedly held that double jeopardy is a fundamental value. In fact, double jeopardy claims have been, throughout the language of this court, given even more importance, far more importance than delayed sentencing claims. Yet this court held first that double jeopardy claims can be waived expressly, and then recently expanded that in People v. Muniz, I believe, to hold that double jeopardy claims are waived even with a general waiver. And this claim is certainly akin to that situation. So for these reasons, Your Honors, if there are no further questions, we respectfully ask that the decision be affirmed.
Thank you.
Thank you.
People